I don't like going after Steve Miller. For one, the bar is set so high for a speaker. For two, I am math phobic, and lawyers, unlike clinicians, when asked about 2 plus 2, usually say, it depends. Anyways, so we are going to change gears for this talk. I'm not a scientist, I'm not a PhD holder or an MD, but I do litigate cases of parental alienation across the country and internationally as well. And I'm going to give you an attorney's perspective. What you see on the ground, what do you see in the courts? When do judges sit back and take action? When they do not? And despite our individual stories and anecdotes, which are sometimes full of despair, there are signs of hope. Across the country, we see cases after cases and judicial opinions where the courts have taken note of parental alienation, provided intervention, sometimes drastic interventions, including jail time, sanctions, change of custody as well. For starters, the courts do use this term, parental alienation, and they have not shied away from it. But they also use other terms. They use pathogenic parenting, they use programming, brainwashing, interference, and in some decisions, even simpler terms such as counter-parenting or undermining. In fact, from a strategic standpoint, I usually do not like to throw out the term parental alienation lightly, unless there is strong evidence to support that. You do not want to walk into a court and start alleging alienation unless you have evidence to back that claim. And often, when you're talking about counter-parenting, undermining some of the alienating behaviors, it is the court that takes a pause and asks, counsel, you're not suggesting there is alienation going on, is there? And that opens the door. That gives you an opportunity to ask for a proper psychological evaluation or a custody evaluation without going in and telling the court and yelling and screaming alienation when you might not have the evidence to back it up. Dr. Burnett and Dr. Baker talked about the different terms and definitions of alienation. Let's see what the courts are looking at. So one example, a decision from Michigan Court of Appeals, 2010, the courts look at it from this perspective. Parental alienation is the process of one parent trying to undermine and destroy, to varying degrees, the relationship that the child has with the other parent. That's how the court defined it and used it in the opinion. Now, it's important to notice the term to the varying degrees. And sometimes many judges have misunderstanding of the term. If a child goes to parenting time, if they go to the target parent's time and the relationship is not healthy, but nonetheless the child does make it to the target parent's home, many judges, guardians ad litem, counselors say, well, it's not a case of alienation because the kid does go to parenting time and it's not outright rejection of a parent. Well, what they fail to understand that it's a spectrum, and you might have a mild case, moderate case, and a severe case. And it's absolutely nonsensical and ridiculous to wait until it gets so bad that a court needs to intervene with drastic measures. And children who are alienated, often, while they are kind and great in schools and other spheres of their lives, are absolutely despicable to the target parent. And that's sometimes shocking. But not all cases are that kind of case of severe alienation. And the judges and the guardians ad litem will sit back and don't take action. I call them enablers. There is no other word for it. delay is death in these cases. You can't delay, you need intervention. And what's worse is that you have a mild case of alienation going to a moderate case, and the judge or guardian ad litem who are not used to these cases, who are not trained, who don't have understanding, make the mistake of thinking intuitively. Exactly what Dr. Miller talked about. We can resolve this by going to therapy. And off they go to traditional therapy, which makes it far more worse. And 5 years down the line, the same judge or the same professionals are so frustrated and exasperated, and they basically say, well, the kids are 15 and 16 and 17. I'm not going to send a deputy or a sheriff to force a kid to go to parenting time. It's just too bad. And that does happen. And the question is, would the same judge or a GAL or a professional act in the same fashion if the situation was about physical or sexual abuse? Would they have waited for weeks, months, years at times to take drastic intervention or any intervention and see how the situation pans out? So this is where the lawyers have to be vigilant and be aggressive in court. Let's look at example 2. This is from Tennessee Court of Appeals. Parental alienation is primarily a description of the psychological condition of a child. And the essential feature of parental alienation is that a child allies himself or herself strongly with one parent, the preferred parent, and rejects the relationship with the other parent without legitimate justification. And this court cited Dr. Burnett's article on CAPRD in support of this definition. Yet another definition out of New York, 2018, where the judge adopted the legal standard for a tort, intentional infliction of emotional distress, and set out the steps which are required for a legal standard to meet alienation. But it's well accepted. Don't let anyone tell you that the term or the phrase or the phenomenon is controversial. That yes, in New York or California, the judges might accept that, but here in the heart of Georgia or Texas or Midwest or wherever you are, our judge is not going to take it kindly, or he's going to have, or she's going to have a different opinion. Courts around the country are headed in the same direction. They've taken note of this phenomenon. They've talked about how dangerous and harmful it is, and they've taken action. It's 2019, folks. The debate is over. This is from a decision in 2018, New York. There is no doubt that parental alienation exists. It's not a gender war over the children, and the court rejects any such simplistic analysis. The PA, parental alienation, has also passed the gold standard, the Daubert test. A couple of weeks ago, there was a decision out of Maine where the Court of Appeals affirmed the trial court's acceptance of expert testimony on parental alienation, and the Court of Appeals held that it meets a test of reliability and validity. I like this book, the chapter written by Dr. Lorandos, which has an excellent summation of cases across North America, the United States and Canadian decisions. The book was published in 2013, and when I find a skeptical judge or a GAL who is not so convinced about the science behind the theory or the theory itself, I use this chapter to make a point that it's an exhaustive research study of all the cases where the courts have intervened. And the book has a CD-ROM in the back which has hundreds of cases where the courts have taken notice. There are cases where fathers have been alienators. There are cases where mothers have been alienators. There are cases where grandparents, extended family members have been alienators. Sometimes you see professionals enabling alienation as well, inadvertently or advertently. And we see continued signs of hope. some of the recent decisions in the past 3 or 4 years from different parts of America. I picked these cases mainly out of Washington, California, South Dakota, Minnesota, Michigan, Ohio, Tennessee, Maine, New York, to make a point that we are seeing good cases, we are seeing progress, and we are seeing courts taking intervention. And no matter what algorithm you use, 17 strategies of Dr. Baker, the 8 symptoms of alienated child, the 4-factor test, not everybody agrees as to which way to go forward. But there's a massive amount of overlap in this. In my experience, what usually gets a court's attention, though not always, but judges are more sympathetic to that argument, is when a child displays lack of ambivalence, when the judges or the guardians ad litem see absolute polarization, black and white. My mother did not do anything right. There is not one single thing I can recollect about my mother that was good. My father was never present at any of my soccer games. He was never around, when the evidence is to the contrary, massive evidence. And when they see this black and white polarization, often they start thinking about it, that we need some more intervention, we need a proper professional to look at this. And another thing to remember is that courts around the country have agreed that presence of alienation or presence of alienating behaviors do lead to material change in circumstances. Now, why is that important? It's important because this is a crucial finding that your lawyer needs to put on a case in order to get to a trial or an evidentiary hearing. In most jurisdictions, you need to show either proper cause or change in circumstances to get to an evidentiary hearing. That's when you present evidence. Until then, it's all simply an argument, allegations out there. And in order to get to a trial, you need to meet the threshold. And the courts around the country have agreed that presence of alienation does meet that standard. Another common feature are the courts sitting back and taking note of what they call abusive use of conflict. Repeated CPS complaints, repeated police complaints, repeated false allegations which don't go anywhere, unsubstantiated. And the courts have found that that's a deprivation of normal childhood. And that needs intervention. Now, if you are a target parent, what tools do you have in your toolbox? The first is contempt. Don't let violation of court orders slide by. Hold professionals accountable, whether that's a counselor, a guardian ad litem, your own lawyer, the court. If you have a signed order for parenting time and that's repeatedly violated, file motions for contempt. Seek accountability. I'm going to skip the few of those to go to the next one, which is important. Emails and text messages are crucial if you're going to get to a trial. This morning, Bob Loden talked to us about evidence and how evidence was momentous in his case. And they had lots of evidence. There are cases after cases, in the ones that I cited, where the courts took intervention. Why? Because the phones were examined forensically and the text messages revealed a propaganda. One example from the Tennessee case that I cited earlier is his father here, who was being very self-serving and duplicitous in front of the court, saying, oh, I want the kid to go and see the mother. I absolutely want a good and healthy relationship. It's a kid who doesn't want to go and see the mother. It's not me. And when the text messages were uncovered, this is what they revealed. A propaganda of the father telling the child, you have a right to be ugly to your mother. She is mentally ill. The Bible tells us clearly that mental illness is a spiritual problem. You will never like her. Nobody likes her. And on and on and on and on. And these evidence, all of this put together allows an expert on the stand to talk about what are the alienating behaviors, what are the consequences, what can we do to stop this and make it better. There are sanctions, incarceration, jail for repeated contempt violation, financial sanctions including recovery of attorney fees for compelling a target parent to go down that path. Some jurisdictions, such as New York, has self-executing fines for future violation. Each time your kid misses a parenting time, $1,000 sanction. Every time a child refuses to go on a court-ordered parenting time, and you as a parent cannot make that happen, $1,000. Your kid goes to school, you make it happen, make the parenting time happen. Either you are an incompetent parent or you are an alienator. There are courts that have done that. It's not impossible. But despite this progress, there are concerns where we have cases after cases where the trial courts found no evidence of parental alienation and refused to take intervention. There are court opinions where you have several multi-day trial, experts testifying, but at the end of the day, the court refused to do anything because no evidence. And when you dissect these opinions, sometimes you find that it was a premature rush to the court. The evidence was not collected, not organized. It wasn't put before the court properly. It wasn't utilized properly. And basically, the lawyer or the expert or the team who were in charge to put the case together simply didn't do their job. This is not to say that the courts sometimes miss the boat as well. They do. But it requires enormous amount of time and effort to put a case of parental alienation together. And there are plenty of opinions out there where the courts found one parent alleging alienation against other, or both alleging alienation against each other, and the judges don't know what to do when there's no evidence there. Let's skip that. So, don't let the status quo become the new normal. If there are signs and red flags, don't let them be ignored. The top 5 takeaways I would give to you are: do not delay. If there are red flags and there are concerns, get them addressed. Talk to your lawyer. Do not accept an answer that in your jurisdiction, so-and-so judge is not going to like the argument of parental alienation. There are cases after cases in several jurisdictions across America where you will find good law. And the lawyers need to be aggressive. They need to do the hard work and stop being lazy about it. Second, do not agree to voluntary suspension because the kid is acting out. The cooling off period, which the professionals love many times because it's an easy way out, over-empowers the child. It allows them to dig in. It allows the alienating parent to go and work on the child more. And after that cooling off, you never resume the parenting time. You are on a sliding slope and it always gets worse. Do not agree to over-empowerment of the children and appointment of professionals without thinking it through. If you are fortunate, you might get a good guardian ad litem who is competent, hardworking, understands the case, and will take the time to learn the case. More often than not, that's not the case. If you get a professional who's going to look at the case with a cookie-cutter mentality and do what they've been doing, or worse, use their clinical intuition, I've been around for 25 years, I exactly know what to do, then it's going to get worse. You will have the alienator, you have the kid's therapist, you have a GAL, and all of a sudden you have an army to fight against. And do not hand over the parenting decisions to GALs or professionals or therapists. Many times we see the judges basically passing down the decision making. Well, I'm going to go by what the therapist recommends in parenting time. I'm going to go with the GAL's recommendation. And the lawyers for target parents often comply with those things because they want to good look to the judge. They want to try to convince a judge that my client is not the problem client. We are being reasonable. Well, being reasonable in the case of alienation kills you. You cannot be reasonable with someone who has been engaging in alienation. And when all fails, or even when you succeed, there are other avenues to explore, which is a lawsuit in tort, exploring remedies in tort, thinking outside the box, getting discovery when you would otherwise not get the discovery in a family law setting. And that also should be explored. And that's what Dr. Lawrence is going to talk about now.
So where's my clicker? Is that it? That's clicker. What? How do I do it? Show me.
Well, see, this goes back,
Back?
that goes forward.
Okay, good. Forward is that way?
Yes.
Forward is that way. I'm Demosthenes, and I'm going to talk about something that's heretical. And the reason I'm going to talk about something that's heretical is because we know that for hundreds of years, courts in English-speaking jurisdictions have been dealing with parents acting badly and wrecking the relationship with the other parents and the children. And we know that sometimes they do a good job and sometimes they do a bad job. So I'm going to talk about what is in Chapter 7 of the new book that Dr. Burnett and I have been working on since the spring of 2017. It comes out in 2020, the spring of 2020, thanks to the hard work of many of the people that you will see here. Well, research shows, and I'll be talking about this tomorrow, that there have been hundreds and hundreds of cases of parental alienation dealt with in United States jurisprudence. And sometimes, even though it's a common occurrence, parents just don't get the relief that they need. Now, Mr. Joshi made it clear that strong, immediate sanctions are valuable. Certainly, in the 40 years I've been doing this, that has worked, but judges rarely do that. Maybe it has something to do with the nature of family courts. So I would suggest to you that sanctions are sometimes wishy-washy. Children are brainwashed and participate in their own alienation. It's difficult to enforce fines and so on in family courts. They're reluctant to do that. Their dockets are crowded. Well, I'm going to talk about something that's somewhat heretical. I'm going to talk about something that I would like to see more people do, and that is sue the bastard. Intentional, and I don't mean sue the therapists that have been trying to remediate this. You know, recently people have been suggesting, well, you know, if they don't get it right, they're just contributing to the problem, and we should sue them or file a licensing complaint. Don't fracking do that. We want them inside the tent pissing out rather than outside the tent pissing in. So we would rather bring them along and help them do a good job. I mean, I would like them to go spend a week with Linda. You know, I would like them to go spend a week with Yvonne. I'd like them to spend a week with... Don't sue them. Get them to help us. Anyway, so why should we do... What kind of tort should we do? Well, intentional infliction of emotional distress, loss of consortium, defamation, false imprisonment, conspiracy, negligent investigations. Well, forcing parental alienation into one area of law is... I think it's destined to fail in the long run if in severe cases, because as we know, dealing with severe cases of parental alienation, sometimes the alienating parent is just too far gone. No matter how hard the programs to remediate this work with these parents, They're just not going to get it. I mean, Linda told us about psychopathy. Certainly, Dr. Miller testified this many times. Amy Baker's research is profound in the area of the kinds of things that these folks do. So I'm suggesting that maybe we should look at different approaches, like Raftery versus Scott. This was an alienating mother. She disappears with the kid, right? She's caught. She says, well, it's been so long since Junior has seen Dad. He's a jerk, and it would be negative for him. So Dad sues. And what happens? The jury awards him $40,000 in compensatory damages and $10,000 in punitive damages. And the mom appeals, no, he can't do that to me. Well, the court says the fact that a tort may have overtones of alienation of affection does not bar recovery on the separate and distinct accompanying wrongdoing. Bama versus Bama. I'm a retread. I went to law school when I was like 75 years old. And Bama versus Bama was just happening. So I went, it happened with a Detroit lawyer, and I was going to the University of Motown to law school. So I went down to the lawyer's office, and he said, okay, doc, here you go. Stuck me in the conference room with his entire file in Bama versus Bama. The alienator in this case was a father. He was a psychiatrist. Boy, he was good at it. And the mom couldn't get anywhere. So what happened? In Bama versus Bama, mom sued. And it was a 7-year custody battle. And so mom sues for compensatory damages for intentional infliction of emotional distress. And the appellate court said, we are unpersuaded that the deliberate destruction of a parent-child relationship can never be recognized as outrageous conduct. Boom! A winner in intentional infliction of emotional distress. And then, if we look at Sheltran versus Smith, we see that in this case, the alienator was a father. And between 1977 and September and October 77, the father said the court record maliciously, intentionally, outrageously inflicted extreme mental suffering, acute mental distress on the mom by willfully, maliciously, and outrageously rendering it impossible for any personal contact with the other other communication to take place between the plaintiff and her daughter, Monica Smith. Yeah, how often do we see that? Well, couldn't get very far in family court, so what did mom do? She sued the bastard. And what happened? The court threw her case out. But the Court of Appeals said, we find the complaint adequate. It alleges the 4 elements of the tort necessary to establish the prima facie case, outrageous conduct. Yes! Done with intentional or with reckless disregard for the probability of causing emotional distress. Sound familiar? Resulting in the suffering of extreme emotional distress. Yeah? Actual or approximately caused by the outrageous conduct. So what happens? The court says, it is the task of the law to remedy wrongs which merit redress even at the expense of incurring a flood of litigation. What do the defendants say in these cases? If you allow the tort like this to go forward, the floodgates, the litigation will open. Don't study gun violence, because let's make a law you can't study gun violence. Let's make a law you can't study cigarettes and they're bad. Let's make it because it'll be a flood of litigation. Yeah, okay, let's have a flood of litigation, because maybe that might be one way to stop this kind of behavior. So the court said, boom, the case goes forward. So here we have an alienator who's a mom. With the help of the maternal grandparents, in this case, the kids go to Disneyland. Then then they get shepherded out of town, and then they disappear. And then the father says, well, what the heck, where are my kids? And the grandparents all of a sudden, Disneyland? What's Disneyland? Motel? We don't know anything about a motel. Address? No. What town was it in? We don't know. So the last time the mom and the kid were seen after they disappeared was in Switzerland. So what did Dad do? He sued. He sued the grandparents that facilitated mom absconding with the kid. And you know what? He won. Okay, what about lawsuits concerning interference with custody and visitation? Well, in Wolf versus Wolf, we had a mom alienator. Custody was given to mom in Iowa. Then it was switched to dad. Then it was switched back to mom. Then dad wanted an appeal, and it came back to dad. Then mom won't return the kid. The mom takes the kid to Arizona, won't return the kid. Then the dad gets rid of habeas corpus. Ugh, please. Family court, family court, family court, family court, family court, family court. On and on and on and on and on. So mom absconds with the kid. Or the kid, no, mom calls the kid and says, yeah, I know dad's got custody of you and you're in Iowa, but, I'm sending you a plane ticket. Kid goes back. Dad says, okay, that's it. I quit. I sue. So the father sues, and the court says, following a Wood versus Wood decision, they say that the trial court denied the mom's motion to dismiss for failure to state a claim and affirmed the award of compensatory and punitive damages for the father. So then we have Streeter versus Executive Jet Management of Connecticut. A jet company? What's that got to do with parental alienation? Be creative. Be creative. Okay, it turns out that the father alienator, in this case, takes the kids and goes to Egypt. Try calling Hosni Mubarak on the telephone and asking to get the kids back. Good luck with that. So the kids are all over the place. The kids were finally found in Cuba. The mom had to spend millions of dollars. Does that sound familiar? Millions of dollars in Egypt and in Turkey. I'm a Greek, so don't talk to me about Turkey. And Cuba, right? And New York and London and Houston and here and there and here and there. So she sues the company that puts the kids on the plane, even though she's got custody. She's got legal custody of the kids. And she wins. Millions and millions and millions of dollars. Sue the bastards. I know this is heretical because we're supposed to be trying to work these things out. And when I go to court as an expert or as a lawyer, that's what I try to do. But as you know, if you've seen me in these previous conferences, you know that they let me out of the cage and I come up and say a few crazy things and then they put me away. So my crazy thing for today is sue the bastards. Okay. A couple more. Just a couple more and then I'll shut up. So in 1982, we have a mom alienator, custody to father in 79. Mom refuses to return the kids. The Wisconsin Family Court, no help. The Wisconsin Criminal Court, no help. Private detectives, no help. So she sues, and the court awards her $70,000 in compensatory damages, for which the grandparents who facilitated getting the kids away are jointly and severally liable. $25,000 in punitive damages to grow by $2,000 every month until the kids are sent back. Don't be a chicken. Tell your lawyer that she's got to think about this. She can call Dr. Lorandos on the phone, or she can reach after 7 when the book comes out. Take heart. Sue them. Okay, so in Gibson versus Gibson, we have a father alienator that was sued, and and naturally mom lost her case, but what happened? The court put the case back on the docket. Mom won the case in the appellate court, affirmed. In DiRuggiero versus Rogers in New Jersey, we have a woman alienator. And the dad sued. I love this part. So the dad sues the current husband, the adult child that facilitated this, and the alienator's lawyer. And he won. Okay. Hello, I'm Dr. Lorandos. So, in Everly versus Adams, We have a woman alienator, mom, boyfriend, and grandparents, and the aunt all collude to hide the kid away. What happens? They get sued. They lose. How about lawsuits concerning loss of maintenance and support? Well, they go back a long way, back to 1945. And this is all available to you in the book when it comes out and also in this PowerPoint. We have more suits in the 40s, alienation of affection lawsuits. Some states have abandoned that, and you need other theories. But I put these in here to give you some heart that the cases based on alienation of affections, which courts understand, like product disparagement, defamation. Oh, I'd like to use Acme's widgets as well, but Acme widgets are made with poison Chinese plastic. So, good luck with that. That's defamation. That's defamation of a product. That's intentional interference with a positive business relationship. If that works, and you know about this, Mr. Joshi, because you do business litigation, if that works, then why can't you sue them for defaming you as a parent, right? You're worth more than Acme's widget. Okay. So, Russell versus Hicks, Miller versus Monson, lawsuits concerning loss of society and companionship, Rosenfeld versus Rosenfeld, on and on and on and on in this PowerPoint and in Chapter 7. Huelmeyer versus Cox, North Carolina. The scholarship in this, I think, is important to do something that you may not have thought to do, particularly if you said to your lawyer, excuse me, can't we sue them for this? And the lawyer says, well, I don't. Yes, you can. Take heart. Yes, you can. Do things creatively. Even working up a lawsuit like this may help empower you, give you a sense of empowerment to get into a different court that's not bogged down with a choked, horrible docket and is not set up like a dependency court that dealing with dependents, neglect and abuse cases. And it's just trying to deal with money and visitation times and so on and so forth. If you get into a civil court for money damages, you may be able to leverage. So, soon, we've been working on it since 2017, thanks to all of the gracious help of Richard Warshock and Dr. Freeman, a psychiatrist at Vanderbilt, and Mandy Matheson and Jennifer Harmon and Amy Baker and Ashish Joshi and so many people that contributed to this effort. You'll be able to read about many of these things in this upcoming book. I realize this is sort of a shameless plug, but actually, PASG has been supporting this effort. And the whole point is to give you information about alternative ways of dealing with this that may empower you to have a better sense of redressing the kinds of problems that have occurred to you. In addition to that, let me say that Mr. Joshi quite rightly described a number of cases and the way that the courts are dealing with them. Tomorrow, or the next day, I don't know. Well, thank you. I'm going to be talking about 34 years worth of research. We did a big research project that was supported by PASG and my company, Cyclaw, and for years by Mr. Joshi's law firm as well, documenting how courts have dealt with cases for the last 34 years all across the United States, more than 1,000 cases, almost 1,200 cases. We'll be talking about that tomorrow. But if there's one takeaway from my part of this, it's that there are other ways to seek redress for the terrible things that have happened to your children and are happening to you. Take heart, stick together. Don't sue people or complain about people that are trying to help. Get everybody together and try to stop this pernicious child abuse. Thank you.